You don't certify anything. It's a verifiable claim. See, certified just means that somebody else believes that that piece of paper exists. When you go down to a notary certifies the document, correct? Okay, yes. What happens is all you're asking the notary lady to do is say that this piece of paper existed on this day. She doesn't read the document. She couldn't care less what's on it. You can't bring her forth to the court to have her verify that anything on that document is true. Certified just means that there's another person that believes that piece of paper exists. Certified is a total joke and is a waste of time. What you need to do is have it verified. See, lawyers can only certify things. So if you read at the bottom of every lawsuit, it's like, I certify everything in here to be true, whatever. That's all nonsense. Yeah, or read everything that everybody cut copies and pastes. Every Title 42, 1983 complaint, you'll see everything at the bottom is certified by you pro se plaintiff people. You don't certify anything. Lawyers certify things. What you do is verify it, and you demand that the other side also, the only answer that you'll accept in court is a verifiable answer. And the other side can't verify their answer. They could only certify their answers. So in this land, to give testimony in open court, it has to be verifiable. It can't be certified. It's got to be verifiable. There's got to be a man who's willing to put his hand on a Bible and swear to it. That's verified. That's the difference between verified and certified. Verified is viva voce. It's by your voice, by your mouth. If it doesn't come viva voce, just Google viva voce, and you'll see what I'm talking about. And
I tried to pull that today. I asked the judge, because they switched the prosecutor on me, and they still haven't, the prosecutor still hasn't had a meeting with me. So I ended up, I said, maybe I can use this to have the, do a catch-22 and have the prosecutor swear in. And I think you've made that comment, the prosecutor won't do it. So I asked the judge, can you swear us both in? And he said, no, we're not going to do that.
Well, you told him, you said you need it for appellate review. Say, is it not true that for any evidence or facts to be presented to the court, it has to come through a verifiable witness? And he'll have to say, yes, that's true. So say, before we start, just in case I need it for appellate review, I need to be sworn in, so that way my testimony can be heard by the appeals. Because if you don't, the only testimony that the appellate court is going to hear is something that was verified under oath of affirmation. So if it's not verified under oath of affirmation, you have nothing to appeal.
Really?
Really? Yeah, it's just that simple. I mean, all you have to do, it's a federal. If you actually like to play with federal rules, it's a federal rule of civil procedure, Rule 602. It's just personal knowledge. So, like I said, the only thing you have to say anytime you ever step before any kind of court is just that you have to say to the judge, is it not true that for any statement to be deemed admissible evidence, it has to be under oath of affirmation? And the judge has to say yes. He has no other choice. To be admissible evidence, you have to. And then you say to the judge, therefore, before we proceed, you just say, it's my wish to be sworn in through affirmation. Therefore, there could be admissible evidence pressed upon the record in the event that it needs to go for an appellate review. And that's the appellate court only reviews things that were sworn in under oath of affirmation testimony. If there's no testimony for the appellate court to review, there's no case for them to hear. So you say, therefore, before we proceed, it's my wish to be sworn in through affirmation, and then I wish the other side to do for the same. And in the event you need an appellate review, and Angela sees that on, she put that on her Irwin Schiff site. That case that I'm referring to is that Transi versus Pagliaro, 1964, where it says that no attorney could present any facts or evidence or onto the record unless he has any firsthand knowledge, and that's that federal rule of evidence 602.
Well, it's the state of Florida against me in all capital letters. So I thought this should be an easy one to shake off. And
it is.
It's well, trust me, it's not looking good so far because the judge is in on it too.
Because the only problem is that you didn't file a claim, did you, against them?
Actually, you know what I did? I just I've been playing in the private. This time I filed a motion for a show cause hearing, a declaratory judgment in the nature of a writ of error, quorum nobis, and a demand for dismissal for failure to state a proper jurisdiction and venue. He didn't. It was like I didn't do a thing. He just ignored it.
Well, the big thing is, like I said, you don't ever motion a court or petition a court. That's begging the court. And once you motion a court, you're giving the court jurisdiction, because you can't order something to do something that doesn't exist. So you kind of look like you're an idiot to yourself. You know, like you're turning on yourself. It's like you're motioning a court. Motion a court for what? You notice the court that it lacks jurisdiction over you. You notice it. You give it notice. You don't motion the court that it has no jurisdiction. That sounds ridiculous. You're saying, okay, court, you exist, but I'm saying you don't exist and you don't have any control over me. Then why are you talking to the court then?
Guys, so I thought you said originally you weren't talking in court. Now you are?
You give the court notice. Now, when you see you got a notice on a bulletin board, what do? You put it in writing and you wrote the word notice on it. I believe that there's no man will come forth and claim that they have jurisdiction and control over me, because all jurisdiction means is control over you. Who's got the power to touch you and drag you in? Who did you cause harm? Because, like I said, it's very simple. Everybody knows the 10th Amendment says that whatever power isn't reserved with the federal government, the power is reserved then with the state and with the people. And power means the control over another person. So you have control over me when I'm stepping on your toes. If I'm stepping on your toes and you say, hey, buddy, you're stepping on my toes, back off, and I don't, well, then you have the power to control me, to control my actions. You have the power to push me off your feet. So you have jurisdiction and you have control and authority over me at that time, because it's necessary for your self-preservation. So you have the jurisdiction. All jurisdiction means is you have the power to drag me into a court before a jury. Do you have that power? Do you have that authority? Of course you do. If I've caused you harm and you could prove that harm and you're willing to prove it, and I won't settle the matter with you on a private side outside of the courtroom, you have to drag me in. So that way you get the marshals to drag me in or the sheriffs to drag me in to answer to your claim against me. So you have the authority over me, jurisdiction. That's all jurisdiction means. So you're challenging the judge. What man did I cause harm to that I was not willing to settle this matter on a private side, that you believe, or somebody believes in this building, that you have the right to summons me here, drag me in, and then force me to do something? Who's got that power over me? So the judge would have to say, well, he does. It's like, okay, so you're claiming I've done you harm? He'd be like, well, no. Well, then you don't have jurisdiction over me. Who's got the right to claim that I caused him harm? Let that man come forward and speak his piece. I'll settle any matter that I've caused any harm to anybody. That's all jurisdiction means. You guys must be getting extremely confused what the word jurisdiction means. It just means who's got the right to control the power over your body.
Right. And when the supposedly going to your brother, the prosecutor, they've been avoiding me like the plague. So what do you do?
The prosecutor is not the person that you've caused harm to. What you need, if you're saying that the prosecutor is, that's like the prosecutor has to be prosecuting a claim. So you say to the prosecutor, whose claim are you prosecuting? Bring the person that I've caused harm. The prosecutor is more like the trustee. He's the one who's actually just performing a job for the person who made the claim, the trustor, the grantor. Right. So who made the claim? The prosecutor didn't make the claim. He's the trustee. He's acting on that claim. He's the worker. He has an EE at the end, like an employee. He is the trustee. He's the one who's moving the claim. The claim for who? Please bring the grantor, the trustor forward.